Dear learners, today in my lecture I would like to discuss a topic or subject that is linked with the next topic that is inheritance. The topic which I propose to discuss today is called as administration of the estate of a deceased Muslim. It is a very well known fact that as and when there is a demise or death of any owner of the property, his property is to be applied and administered either according to his wishes or according to the rule of law applicable to him. So, basically the administration of estate here means management and disposal of an estate or property, whether it be that of deceased person or of any other person. Here we are concerned only with the administration of the estate of a deceased Muslim. On the death of the Muslim, the question like who get the right to share the property of the deceased, in other words, who would be entitled to succeed or inherit the property of the deceased, whatever is left by him. So, who will take over the property of the person who has already died? What will happen to the unpaid debts of the deceased and the legacy left by him or her? These are the some questions which are of substantive nature, but question like who should immediately take over the property or charge of the property of the deceased, this is also an important question that arises normally in the event of the death of the owner of the property who happens to be the Muslim by religion. How to deal with the claims for and against the deceased? So, these are the some important question in nature that normally arise and are to be addressed by the law. Therefore, the management and disposal of the property of the death of the Muslim owner and the application of the same for different purposes in order of the preference is known as administration of the estate of a deceased Muslim. So, administration here means management, disposal and application of the property of the deceased according to the rules or personal laws applicable to him or her. In fact, is called or is known as administration of the estate of a deceased Muslim. But administration as understood in modern law was unknown to the Islamic jurisprudence. In Islamic law, there is only distribution of the property of the deceased, and the work of the distribution of the property of the deceased is to be performed by the state, if not by the heirs themselves. This means that on the death of the Muslim, his or her property is to be distributed among the legal claimants by the heirs of the deceased themselves. In the default of the heirs or in the absence of the heirs, it is the responsibility of the state to manage and dispose of or distribute the property of the deceased among his legal claimants according to the rules governing the devolution of the interest of a deceased Muslim in his or her property that has been left or that is left after his death. Therefore, unlike the other legal system to dispose of the estate of the deceased Muslim, neither there is a need of the executor or the administrator nor probate or letter of administration, because under the other legal system, for the disposal and management of the property of a deceased, the rules are entirely different, and the rules governing the disposal and management of the property of a deceased who does not belong to the religion of the Islam require that someone should have been appointed as a executor or administrator of the property, and he or she should have been granted a letter of the administration. Only then he can manage and dispose of the property of the deceased, otherwise not. It may be clarified here that in the absence of any executor appointed by the will of the deceased, heirs of the Muslim have right and capacity to dispose of the estate of the proprietors according to the rule of Muslim law. In case there is no executor appointed by the deceased, also there is no legal heir to manage and apply the property of the deceased. In that very situation, according to the Muslim law, Qazi or the magistrate may appoint any suitable person as an executor of the property of the deceased who will take the necessary steps for the management and disposal of the property. Therefore, unlike the other legal system, the estate of deceased Muslim immediately on his death or her devolves on his or her legal heirs. The person primarily entitled to administer the estate of the deceased Muslim, or that is executor appointed under the will by the deceased Muslim. If the deceased left no will, the person entitled to administer his estate would be who is appointed as administrator by the Qazi or court of the competent jurisdiction by granting him to a letter called as letter of administration. The persons on priority entitled to be appointed by the magistrate as administrator are the heirs of the deceased, In the absence of an executor or administrator, the persons entitled to administer the estate of estate or heirs estate of the deceased are his heirs, that is the heirs of the deceased person. According to the Muslim law as laid down in chapter 4 verse 11 and 12 of the Holy Quran, the estate of a deceased Muslim is to be applied in order of priority for the payment of following purposes: funeral expenses, debts, legacy, claim of the heirs. The author of a very celebrated authority on the subject of miras or inheritance, that is author of Al-Sirajiyah. Al-Sirajiyah basically is a book, authentic book on the subject of miras or law of inheritance. The author of this book has summarized charges and their priorities at the authority of Holy Quran, means for what purposes the property of a deceased will be applied in order of the preference. They are again, he says, I quote, there belongs to the property of a deceased person 4 successive duties to be performed by the magistrate or Qazi. First, his funeral ceremony, means whatever property is there in the ownership of a person who has already died, that some total asset of the deceased will be called as gross property of the deceased. According to the author of Al-Sirajiyah, rule is that out of gross property of the deceased available after death of the owner, first of all, it will be applied for the payment incurred on the performance of the last rites and ceremonies of the deceased. Means whatever expenditure is made for the funeral expenses, for performing the funeral rites according to his religion or culture, so that expenditure happens to be the first and foremost charge on the property of the deceased, and therefore first of all it will be discharged out of the property of the deceased Muslim, that is the gross property. Whatever is left after the payment of the funeral expenses, property will be applied for the discharge of his just debts from whole of his remaining effect or property. Means if it is found that deceased had borrowed money or debts from someone, from some human agency or from any other agency, for whatever purposes money was borrowed by him, and for whatever reasons he did not pay or could not pay back the money borrowed by him, or that is loan taken by him. So, this will remain a charge on the property of the deceased, and this will be the next legal charge running over the property of the deceased after the funeral expenses. So, funeral expenses is the first and foremost charge in order to be paid out of the gross property of the deceased. Next to it is the unpaid debt, and the creditors will be satisfied whatever property is left after the payment funeral expenses. So, out of the left creditors will be satisfied, and in this way the debts will be discharged or cleared. After the payment of funeral expenses, payment to the creditors, whatever is remaining property or will be remaining property, it will be applied to satisfy the claim of legatees or legatee if any, and is valid according to the personal laws of the deceased. So, means the third charge running over the property of the deceased is legacy, payment to the legatee or legatees. If legatee is more than, then all of them according to the rules governing the legacy will be satisfied out of the property left after discharge of the two charges, funeral expenses and debts. However, care will be taken of the fact while applying the property for the third charge, that is legacy, whether bequest made by the deceased is valid according to his personal law, and in order to determine the validity of the legacy, 2 points will be looked into or will be taken care of. One is who is legatee, whether legatee is a lawful legatee or not. Lawful legatee means that wasiyat can be made in favor of any person except the legal heirs. So, if the legatee or legatees after the death of the testator are found the legal heirs prima facie, they will not be lawful legatee, and therefore they may not be entitled unless the other legal heirs consent to it. And second is, what is the extent of legacy, whether it is the within the limit prescribed by the Muslim law, because Muslim law allows a Muslim owner to make the bequest of his property only to the extent of 1/3 of his net total property. If the bequest made by the deceased after his death is found in excess of the limit set by the Muslim law, that is in excess of the limit of 1/3, wasiyat will not be prima facie valid unless the consent of the heirs is obtained, and therefore in this situation as a general rule wasiyat will not be valid and wasiyat cannot be given the effect. However, if the wasiyat is in the name of any non-heir and it is within the limit of 1/3, then of course it will be a charge on the property of the deceased Muslim, and it will be the third charge in order on the property of the deceased Muslim, and will be discharged by making the payment to the legatees according to the rule. The author of the Sirajiyya further says, and the last distribution of the residue among his legal heirs, means after the payment of funeral expenses incurred on his last rite, performing the last rite, as well as payment to the creditors, that is discharge of his debts from the property, and then after the payment of the legacy or after the satisfying the claim of the legatees, whatever property will be left, that property in sum total will be called as the residue property of the deceased, and the residue property of the deceased will be the claim of the legal heirs. Since it will be the claim of the legal heirs, therefore it will be distributed or divided among the legal heirs of the deceased according to the rules of Muslim law, in strict compliance of the rule of the Muslim law. So, this is the manner in which the property of a deceased Muslim will be applied for the purposes as mentioned by the author of Al-Sirajiyya, and the note of the author of the Sirajiyya basically is rooted in the chapter 4 verse 11 and 12 of the Holy Quran. So, in this order or in this preference, the property of a deceased Muslim is to be applied in order to make the proper disposal of the entire property left by the deceased in his or her ownership. Very important. So, the Muslim law recognizes the above mentioned 4 distinct purposes to which the estate of the deceased is successfully applied or is made applicable.